Hi, my name is Susan Gomez, and my presentation is on Audi AG versus D'Amato. Okay, the case background, D'Amato registered the domain name audisport.com, sold goods and Audi logos on his website, used various Audi trademarks, and he claimed to have permission from a salesman at an Audi dealership. Um, Audi dealerships have no right by contract to grant any use of Audi trademarks. So Audi's website sells assorted goods with Audi name and logo on it. They're the only ones that can do that. Okay, so what did Audi sue for? Audi sued for infringement, dilution, cyber squatting. Okay, the plaintiff must prove the defendant registered, trafficked in, or used domain name. The domain name is identical or confusingly similar to the protective mark owed by the plaintiff. The defendant acted with bad faith intent to profit from that mark. Okay, points of defense, fair use such as comparative advertising, non-commercial uses such as parody, editorial commentary, news reporting, or educational use. That would be D'Amato's defense. Okay, what is a trademark? Trademark is a commercial symbol such as a design, logo, phrase, distinctive mark, name, or word. A manufacturer puts it on its goods so they can be readily identified in the market. Companies will spend large sums of money so consumers will recognize and trust their products. And also, there's a difference between trademarks. Audi is an arbitrary and fanciful trademark name. It is inherently distinctive and a made-up name and not related to the product. So it's just basically four round circles, and it's not like a car. Okay, what kind of property is a trademark? Trademarks are intellectual and intangible property. Intellectual properties are created by mental effort, not physical. Intangible property may be invisible, impossible, and harder to value than the physical property. But an excellent reputation, goodwill, and a strong customer base becomes an intangible asset. Okay, advantages of registering versus relying on common law protection of trademarks. Nationwide notice of the trademark owner's claim. Legal presumption of the registrant's ownership of the mark in the event of a dispute. Federal court jurisdiction, forming the basis for obtaining registration in other nations. Filing the registration with U.S. Customs Service helps prevent information of foreign goods that infringe on that trademark. Okay, the Lanham Act allows one to register a symbol with the Patent and Trademark Office, Washington, D.C. Trademark Revision Act provides a nationwide claim to a mark from the time of registration as long as the intent exists to use symbol and commerce. And the Lanham Act strengthens in common law protection. The trademark law allows marks to be registered if they are distinctive and non-functional. The exclusive use can be perpetual as long as the owner uses and protects the trademark. Trademark protection created by priority use first person to use a symbol in a business or a geographic area. It has the right to stop others from using the same or similar trade symbols in the relevant area of activity. Infringement, what is it? It's wrongful unauthorized use of intellectual property rights are infringed. Infringement occurs when a seller causes confusion about the origins of a product by improper use of a trademark. Damages may be awarded to the property holder, and an injunction against further unauthorized use may be issued. fact, the U.S. government estimates that counterfeit and fraudulent use of the intellectual property costs business tens of billions of dollars a year. Okay, what is the Lanham Act? Was the Lanham Act violated? Audi was required to prove likelihood of confusion to obtain equitable relief by these 8 factors: strength of plaintiff's mark, relatedness of the goods, similarity of the marks, evidence of actual confusion, marketing of channels used, degree of purchaser care, defendant's intent in selecting the mark, and likelihood of expansion in selecting the mark. Okay, what is cyber squatting? Cyber squatting occurs when a trademark is used improperly in a domain name with the intent of making a profit. It is restricted by the Anti-Cyber Squatting Consumer Protection Act, also known as ACPA. To prove cyber squatting, the plaintiff would prove the defendant's use of the domain's name was done in bad faith. So the ACPA provides a list of 9 exclusive factors for a court to consider its cyber squatting took place. Number 1 is the trademark or intellectual property rights of the defendant in the domain name, the extent to which the domain name consists of the defendant's name. The third one is the defendant's bona fide non-commercial or fair use of the market in a site accessible under the domain name, the defendant's name in connection with the bona fide offering of the goods or services, the defendant's offer to transfer or sell the domain name to the trademark owner or any third party for financial gain, the defendant's intent to divert consumers from the mark's owner's online location to a site accessible under the domain name for commercial gain, with intent to tarnish by creating confusion to the source, the defendant's giving false contact information when applying for the domain name, the defendant's registration or acquisition of multiple domain names that are identical or confusing to the trademark. And what is dilution? The Trademark Dilution Act of 2006 expanded the rights of famous and distinctive trademarks under the Lanham Act. The owner of a famous mark that is distinctive inherently through acquired distinctiveness shall be entitled to an injunction against any other person who at any time after the owner's mark has become famous commences use of a mark or trade name in commerce that is likely to cause dilution by blurring or dilution by tarnishment of the famous mark, regardless of the presence or absence of actual or likely confusion or of competition or of actual economic injury. Dilution law only exists to protect quasi-property rights a holder has in maintaining the integrity and distinctiveness of its mark. To see if the plaintiff would be successful in proving there was dilution, they would use a 5-point test as follows regarding its trademark. Is it famous? Is it distinctive? And D'Amato's use of the mark was in commerce, began after Audi's mark became famous. Did it cause illusion of the distinctive quality of Audi's mark? And the conclusion is the district court held for Audi and issued a permanent injunction against D'Amato, his website and domain name. D'Amato appealed. So basically, all 3, the cyber squatting, the infringement, and delusion were proved by Audi that D'Amato had violated. And he used their trademarks and my references. Thank you. Good night.